Hi, small business owners. It's Western Singh from Western Law Firm. Today, I want to continue with the series of the AB5 law, and basically, it's a determination of either your employee or independent contractor. So there are some basic rules provided by AB5 law, which is basically an ABC test, and if the ABC test applies or not, or if there is some other test which we have, I think, looked in the previous video, that there is other test which is applied, which is called Baroli test, which is somewhat, I think, compared to ABC test, is somewhat on the easier side, so that I think the employers, when they are in fight with the person they have hired, everybody is looking, I think, at their designation, and employer thinks this person is an independent contractor, and the person hired thinks I should get all the benefits which a usual employee gets. So this AB5 is very crucial for, like, it will touch each and every business owner. So let's see what's this general rule about AB5 is all about, and what is this ABC test is. So AB5 provides you a general rule which is called an ABC test, and as mentioned in the previous video, that ABC doesn't stand for anything. It's just a 3-factor test, and I will give you details of that, and we will have a discussion and examples about that. So it asks the employers to prove that the employee is not, I think, set in one of the factors of this ABC test. Otherwise, the employee is considered as an employee. Sorry. So it's basically, I think, a burden on the employer to prove that the person is not an employee but an independent contractor. So this general rule of an ABC test, it applies on the wage orders. So if you have any dispute about overtime, meal and rest breaks, those kind of disputes, usually an employee or so-called employee files a lawsuit, which you designate the employee as an independent contractor, and he's asking for all the benefits. And now you're looking at, okay, what to do. I have always been thinking that this person is an independent contractor, so this person files a claim that he was not paid a minimum wage and not paid the overtime, was not given meal and rest breaks, and all other those typical wage and hour claims. So in such a situation, an ABC test as a general rule will apply, and the employer has to prove it otherwise. But I think the one thing the AB5 law has expanded, it's the reach of the ABC test. So I think before you understand, I think, again, the AB5 law and the general rule of ABC test, so you have to understand from where this ABC test is coming from. So it's not the test which is given by AB5 law. AB5 had just expanded the ABC test. So the main origination of ABC test is from a California Supreme Court ruling, which came in 2018 from a case called Dynamics Operations West versus Superior Court of Los Angeles. So this case, which just went through Superior Court, Appellate Court, then Supreme Court of California. So this case provided a ABC test, which is basically 3 factors. And let's see, I think, what are those 3 factors. So the first factor is about control and direction. So if you have hired a person, we will not designate it, just wait for a moment. You have hired a person, and you are controlling and directing that person how to perform that particular job you have hired for, in the contract or actually while performing the job. So let's see the example. If you are asking the plumber, you have hired a plumber, and you are asking the plumber, obviously, okay, this is the deadline, and you have to, I think, perform this kind of work, that my pipe was busted, but you are asking the plumber, okay, you need to choose this kind of pipe. Okay, you have to show at work, and if you have some major project, you have to show at work at 9 o'clock. You have to wear this particular uniform. In addition to that, and I will tell you which tools to use. I will tell you what would be the brand of those tools. And I will tell you, I think, what kind of activity you should do, like how you should just pick that pipe which was busted, and how you should install that pipe. Basically, you are asserting control and direction. And obviously, it's a factual inquiry ultimately, means there is no, I think, clear answer you can give after looking a couple of facts. You have to look the overall situation and all the facts in this situation to determine if there is enough control and direction which the hiring entity is providing or a hiring person is providing, on basis of which you can say no. Means typically this kind of control and direction is asserted on an employee. So this person needs to be considered as an employee. So that's related to the first factor, is related to the control and direction on the performance of work. The second factor, it's all about usual course of business. So if suppose the person you have hired is doing the same kind of work which the hiring entity is performing in their usual course of business, then the hired person would be considered as an employee. And let me give you an example of that. If suppose you are running a trucking business, and in that trucking business you are basically providing transportation services to different customers, and either those customer may be a warehouse vendor or a person who want to transport certain goods to within the state or out of state, and you hire a person and you ask that person to transport a couple of assignments for you of the customer, and that person drives the truck, complete the task, and you just pay that. Usually in trucking industry, that person hired is paid through per assignment work or per load. So you have to consider, first of all, what's your usual course of business. Your usual course of business is providing transportation services to customers. And what you are asking this hired person to do, you are basically asking the same thing, to provide transportation services, to transport these goods for your customers. So basically this hired person is conducting an activity which you conduct in your usual course of business. Basically providing transportation services is usual course of your business. Obviously there can be other laws, and I think it's still debated in courts because it's a new law, and obviously each and every industry will fight it out to get an exemption from this law. And trucking industry currently, as I mentioned in the previous video, that there is an injunction, and that injunction from the federal district court is just basically on that this AB5 law is preempted by the federal law, which requires that if there is transportation of certain goods, the federal law will govern the pricing and also the activity which is performed, because obviously it's interstate commerce, so federal law can govern those kind of activities. So it's still debated in court. But just to give you an example, let's see another example about a cake decorator. So a person who is working in an ice cream shop, and his main work is to decorate cakes. And this person is paid by the business based on number of cakes which is decorated. So he's basically working as a freelancer. The business asks this person to come at specific times or specific days and specific I think time frames and to decorate number of cakes. In that situation, the business is providing obviously all the raw materials, either it's cream, either it's the casing, or it's any kind of designing, which is because nowadays you also have franchise businesses, so any specialized design provided by your franchisor, and this person decorating the cakes is coming on specific time, wearing specific uniform, and again performing the jobs with your tool and also with your own designs. So if you see what's your usual course of business, your usual course of business here is to sell the cakes, is to provide the cakes based on the customer's needs, and you are asking this person to decorate those cakes. So basically this person is contributing in manufacturing of those cakes, and that's also your usual course of business, because ultimately you have to prepare the cakes, because if you don't prepare it, what you will provide to the customer. So this person is helping you out in terms of manufacturing these cakes based on the need of your customers. So this person is also engaged in the usual course of your business, so that meets the second factor. And so this person would most probably be considered as an employee. Let's see this third factor. The third factor provides that if the employer or if the person hired is not performing any kind of similar activity for other people, or it's not his usual trade or business, then that person would be considered as an employee. For example, if suppose your main work is drafting documents, and you ask a person to draft those same documents, and that person is only working for you, and you are paying that person as an independent contractor as 1099, and that person is obviously using your computer, and that person is also providing the services only to your own office. That person doesn't have any independent business, that person doesn't have any kind of specialized license. So obviously, based on this third factor, that person is not engaged in any kind of independent trade or profession which involve this similar kind of work. So obviously this third factor is trying to see that this person should be considered as an independent business or not. So the main thing you have to understand from all these factors, and what the law is trying to address, and probably because when you are addressing a factual inquiry about if this person is independent contractor or employee, the main thing you are trying to look, if this kind of typical work is done by usually an employee in other kind of businesses. So if suppose you are asking for a receptionist service and you are paying the receptionist as 1099, and the kind of work the receptionist is doing, it seems to that you have the control and providing her the direction, and also you are providing her the tool. So it seems to be that she is kind of an employee, because usually that person with those kind of instructions and activity seems to be an employee. The main thing with this general rule, because why it is more rigid than the other Borelli test, because any one of the single factor, if suppose the employer is not able to show that the employee doesn't meet all these three factors, or the employee meets any one of these factors, then this test will designate that person as an employee. So basically this test becomes so rigid that, and I think the riskiest factor and the most dangerous factor is the factor B, which talks about that if the person is performing the work which is usual course of business for the hiring entity, then that person is an employee. So what's usual course? Because it's very broad. You can have, I think, either trucking industry, because of that, I think is shocked about this, I think, law, because all of their employees who are not a salaried employee or who are not on payroll are considered as an employees. So the issue is that they are misclassifying all those people, and probably there are like 10, 15 or maybe 50 independent owner operators who may be under this law designated as an employee. And if you are an employee, obviously there are various, I think, protections which you get, and in addition to that, for misclassification there are like several civil penalties. So it's very important to understand that if you fall under this test, or if you are complying as per this test or not, and designating your employee or independent contractor as such. So we have talked about the ABC test. So this ABC test, as it's originated from the Supreme Court ruling, initially the Supreme Court ruling only applied to the wage and hour claims. Like if a person is asking for minimum wage, overtime, meal and rest breaks, and all other typical wage and hour claims. However, ABC test has expanded this, the AB5 law expanded this ABC test in other directions. In addition to now wage and hour claims, even if EDD have to decide about unemployment insurance, if a person who you fired, who you have an independent contractor agreement with, and you are no longer working with that person, and now that person is claiming unemployment insurance. Basically, that person is saying, I was an employee and I should receive unemployment insurance because this person fired me. And you are thinking now, okay, come on, hang on, means you are not even an employee. So to determine if this person is employee or not, this ABC test as a general rule will apply. So I think the expansion of that test has shaked, I think, every industry, because this is the general test which will apply to each and every industry. So I think from that you can understand why it's fair for all the industry to worry about future of their hiring practices, and also which work to designate as independent contractor and which to designate as a normal employment. Because why it gets important? Because of these penalties, and also later after a couple of years you are able to find that this person is not an independent contractor, an employee. Now you have to figure out that if you have paid this employee as per the number of hours, all those hours will be calculated, and based on all calculation, if that consider or comes under the minimum wage laws. And also you have to figure out about the overtime pay, because if it's over 40 hours or it's over 8 hours a day, then you have to give the overtime, which is 1.5 times. And we will talk about all those basic rules, I think, in the future videos. So you have to understand then the financial burden on your business. If suppose your 4 or 5 employees are claiming that they are employees and not independent contractor, and you have designated them as independent contractor for these number of years, and now suddenly this lawsuit is filed, and you are trying to understand what's going on. So it's very stressful situation. So it's always better, and this is the time to assess all your, I think, hiring person, if you have misclassified them or not, and if you are, I think, probably involved in some kind of situation where you are intentionally misclassifying them, because there is a great penalty, thousands of dollars, which you have to pay. And if state gets involved, they will have their own audit. So the situation would not be a good one for you. So I think in the This video has probably addressed what is the general rule which is provided by the ABC test and also the AB5 law. So in the next video, I will talk about what are the exemptions to this AB5 law. Because if you don't have to follow the ABC test as per AB5 law based on specific exemption, then which test you have to follow? And the test was the Borelli test, and I will discuss the factors in detail of Borelli test so that you can know if suppose you are exempt by AB5, still you have to meet the requirement of the Borelli test to designate your hired person as independent contractor. So let's see in next video, and I think we will move ahead, and I think with couple of more videos we will cover, I think, the basics of the AB5 law. And as usual, I think AB5 law, it's a big development in the I think in the employment arena. So there would be several changes because there would be litigation obviously by each industry who have not been exempted. And let's see means what the courts come up with about definitions or more clarity on these factors and which industry and what kind of work is covered under AB5 general rule and which are exempt. So let's see how it works out, and thanks for watching this video. Thank you.